Preamble. We the people. Signed in Convention September 17, 1787, ratified June the 21st, 1788. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. On its interpretation, matters of debate. Giving meaning to the Preamble by Irvin Chemerinsky. The Preamble to the Constitution has been largely ignored by lawyers and courts through American history. Rarely has a Supreme Court decision relied on it, even as a guide in interpreting the Constitution. But long ago, in Marbury versus Madison, 1803, the court declared it cannot be presumed that any clause in the Constitution is intended to be without effect, and therefore such construction is inadmissible unless words require it. If the preamble is read carefully and taken seriously, basic constitutional values can be found within it that should guide the interpretation of the Constitution. The court has rejected the relevance of the preamble in constitutional decisions. In 1905, in Jackson versus Massachusetts, the Supreme Court ruled that laws cannot be challenged or declared unconstitutional based on the preamble. The court declared, although that the preamble indicates the general purposes for which the people ordained and established the Constitution, it has never been regarded as the source of any substantive power conferred on the government of the United States or any of its departments. In the few occasions over the last century in which the preamble has been mentioned, the court has summarily denied its relevance to constitutional law. But the preamble states basic values that should guide the understanding of the Constitution. First, it's created by we the people. It is the people who are sovereign. This makes clear that the United States is to be a democracy, not a monarchy or a theocracy or a totalitarian government that were the dominant forms of government throughout the world history. Early in American history, in McCulloch versus Maryland, 1819, Chief Justice John Marshall stresses the importance of the government being created by the people. The state of Maryland claimed that it was the state governments who forms the United States and that therefore it is the states who are sovereign. The court rejects this, quoting the preamble and declaring the government proceeds directly from the people, is ordained and established in the name of the people. Second, the Constitution exists to create effective governance for the nation. The preamble states that the Constitution exists to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, and promote the general welfare. The emphasis on establishing a union and access of government to follow it is not surprising because the Constitution was created in response to the failures of the Articles of Confederation, which was a compact among the states where there was a weak national government with little power. Throughout American history, there has been battles over federalism and the authority of the federal government to take actions for unquestionable desirability, limiting slavery, banning child labor, prohibiting race discrimination, protecting the environment. The guidance of the Preamble has been overlooked. The Constitution exists to ensure that the national government, has the authority to do all of these things which are part of a more perfect union and the general welfare. This essay is a part of a discussion about the Preamble with Michael Stokes Paulson, Distinguished University Chair and Professor, University for St. Thomas School of Law, and we can read the full discussion other time. But continuing the reading. Third, the Constitution exists to provide justice. Long ago, the Magna Carta declared that justice requires both a fair process and a fair results. In fact, even before that, the Bible, in Deuteronomy 16:20, said, Justice shall thou pursue. Commentator have said that the word justice is repeated twice to convey the importance of both procedural and substantial fairness. In American constitutional law, this means a requirement for both procedural due process. The government must follow adequate procedures when depriving a person of life, liberty, or property, and substantial due process. The government must have adequate reasons when taking away a person's life, liberty, or property. Fourth, the Preamble states that the Constitution exists to secure the blessings of liberty to ourselves and our posterity. The Constitution is founded to protect individual freedom. It's a society where personal liberty, not the duty to the states, is essential. Interestingly, despite this commitment, the framers of the Constitution saw no need to provide a detailed statement of rights in the Constitution they drafted. In part, this is because they thought the structure of government they were creating would ensure liberty. Also, they were afraid that enumerating some rights inherently would be taken to deny the existence of other rights that were not mentioned. They wanted liberty to be broadly protected and not confined to specific aspects of freedom mentioned in the text of the Constitution. Equality is not mentioned in the Preamble. This is not surprising for the Constitution that explicitly protected the institution of slavery and gave women no rights. But as the Supreme Court has explained for over a half century, equality is implicit and inherent part of liberty. The Preamble does much more than tell us that the document is to be called the Constitution and establish a government. The Preamble describes the core values that the Constitution exists to achieve: democratic government, effective governance, justice, freedom, and equality. So the full discussion, let me take a look. And is another reading. I think we'll do another time. Let's go back here, however. So, okay. Let's see. Matter of debates. The Preamble's significance for constitutional interpretation by Michael Stokes Paulson. The Preamble's significance for constitutional interpretation. The Preamble, or enacting clause of the Constitution, is among the pitchers long went up before delivering the pitch to home plate. It's the provision that declares the enactment of this Constitution by we the people of the United States. That declaration has important consequences for constitutional interpretation. While the preamble does not itself confer powers and rights, it has significant implications both for how the Constitution is to be interpreted and applied, and who has the power of constitutional interpretation. The two biggest overall questions of constitutional law. Consider two big picture ways that is, the preamble affects how the Constitution is to be interpreted. First, the preamble specifies that what is being enact is this Constitution, a term that unmistakably refers to the written document itself. This at once both obvious and hugely important. America has no unwritten constitution. Ours is a system of written constitutionalism, of adherence to a single, binding, authoritative, written legal text as the supreme law. This defines the territory and the boundaries of a legitimate constitutional argument. The enterprise of constitutional interpretation is to seek to faithfully understand within the context of the document, including the time, the spaces in which it was written and adopted, the words, phrases, and the structural implications of the written text. The words of the Constitution are not optional, nor are they mere springboards or points of departure for individual or judicial speculation or one's subjective preference. Where the provisions of the Constitution set forth a sufficiently clear rule for government, that rule constitutes the supreme law of the land and must be followed. By the same token, where the provisions of the Constitution do not set forth a rule, where they leave matters open, decisions in such matters must remain open to the people, acting through the institutions of a representative democracy. And finally, where the Constitution says nothing on the topic, it simply says nothing on the topic and cannot be used to strike down the decisions of representative government. It is not open for courts, legislators, or any other government officials to make up new constitutional meanings that are not supported by the document itself. Second, the preamble, by stating the purposes for which the Constitution has been enacted, might well be thought to exert a word gentle interpretive push as to the direction in which a specific provision of the Constitution should be interpreted in a closed case. The preamble does not confer powers or rights, but the provisions that follow should be interpreted in a fashion consistent with the purposes for which they were enacted. As Joseph Story put it in his treatise on the Constitution, published in 1833, using the example of the preamble's phrase to provide for the common defense. No one can doubt, and this does not enlarge the powers of Congress to pass any measures which it may deem useful for the common defense. But suppose terms of given power admit of two constructions, the one more restrictive, the other more liberal, and each of them is consistent with the words, if one would promote and the other defeat the common defense, or not the former, upon the soundest principles of interpretation to be adopted. Are we at liberty upon any principled reason, or common sense, to adopt the restrictive meaning which will defeat avowed object of the Constitution when another equally natural and more appropriate to the object is before us? The second, Joseph Story, Commentaries on the Constitution of the United States. Finally, the preamble has important implications for who has the ultimate power of constitutional interpretation. In modern times, it has become fashionable to identify the power of constitutional interpretation almost exclusively with decisions of courts, and particularly the U.S. Supreme Court. And yet, while it's true that the courts legitimately possess the province of a constitutional interpretation in case that it comes before them, it is equally true that the other branches of the national government and the state government too possess a like responsibility of faithful constitutional interpretation. In all of these institutions of government, created or recognized by the Constitution, is superior to the Constitution itself, nor is superior to the ultimate power of the people to adopt, amend, and interpret what it is. After all, the Constitution ordained and established by we the people of the United States. James Madison, one of the leading architects of the Constitution, put it best in the Federalist number 49. The people are the unlegitimate fountain of power. It is from them that the Constitution Charter, under which the several branches of government hold the power, is derived. The several departments being perfectly coordinated by the terms of the Common Commission, neither of them, is evident, can pretend to an exclusive or superior right of settling the boundaries between the respective powers, and how are the encroachments of the stronger to be prevented, all the wrongs of the weaker to be redressed, without an appeal to the people themselves, who, as the grantors of the commission, can alone declare its true meaning and enforce its observance. The Preamble thus may have much to say quietly about how the Constitution to be interpreted and who possesses the ultimate power of constitutional interpretation. In Act's written Constitution, with all that implies, it describes the purposes for which that document was adopted, which has implication for interpreting specific provisions, and it boldly declares that the document is the enactment of and remains the property of the people, nor the government, nor any branch thereof, with the clear implication that we, the people, remain ultimately responsible for the proper interpretation and application of what it is, in the end, our Constitution. Okay, further reading. Okay. We'll do that later. Let's go back. Okay, let's conclude on the interpretation of the Preamble.